Yes, Dr. Sahoo, your views on both.
As I mentioned earlier, everyone has many options for resolution, like the scheme of arrangement, RBI Prudential Framework, IBC. But if one is really interested in resolution, he does not need any framework. He can sit with debtors and can sit across the table, work out an arrangement, do not need any blessing of the any court, do not need IP, do not need anything. But there are two problems. Problems with our system is that one is we want certain benefits while resolving this case. We want moratorium, we want binding nature of the NCLAT order, we want so many tax benefit adjustment against that. We want that 66% of the people will decide which can cram down others. We want that let somebody's some set of people decide matters for everybody, and everybody is bound by that. All these benefits come along.
I think we've lost Dr. Sahoo. I think till he sort of rejoins us, I
have joined. Today I never had this kind of problem, this much a problem. So I was telling that, can you hear me now?
Yes.
Yes.
So I was telling that we need a framework only because we want all these benefits. Pre-pack is something which has developed elsewhere in the world as a market process. It has evolved from the market without backing up the any law. Ideally, that should happen. But because pre-pack has happened in USA, UK, and that was misused to some extent in UK, now they have some framework, they call it SIP practice number 16, some kind of pre-pack pool to evaluate whether it is a good deal. Some amount of regulation is coming. But people here, they think that since there's a facility in USA, UK, why not bring that facility here and put it in the law? The whole problem is we do not want to solve the things on our own, for which you have unlimited freedom. Because you want to restrict the freedom of somebody else, you want to resort to these forceful means, statutory framework, binding nature. So now there's a demand that you provide something within the law. That would mean essentially an amendment of the code. There was a committee under my chairmanship. We have done the work, submitted the report. We do not know when government is going to do, but basically the framework is this, that there will be a one-liner, two-liner provision in the code, just giving an enabling provision. Because it is an informal arrangement, it should be left to informal process, or at best to be done by the market practice and subordinate legislation, except the enabling provision. So details will come out in the further elaborate legislation, subordinate legislation. The idea is that unlike if you want to put it in law, it will be slightly different from what has developed in the market in US. What is proposed here is that let the parties discuss among themselves, have some kind of consensus, then go to NCLT and say that we have this far. From now we want your blessing. We have done the cooking of the food. Now we want to eat it here, serve it, and then have a picnic. This is the basic idea actually. Do the pre-understanding, and how much pre-understanding I am not telling, because until government does it, but and how to go about also. We do not want a very rigid process for informal part. Otherwise, it uses all flexibility, all benefits. But the basic structure of the code, namely the creditors are supreme, that will remain even if you do understanding, you do with the creditors, but 66% approval has to be there. It has to maximize the value. So basic structure of the code will not be compromised. Within that, we will allow flexibility. This is what pre-pack is being thought of. I told you two problems. One is this, the other is why the question was that your first question was that how to improve the things, why things are not happening. It is because again our nature that we do not want to let it go. Except that this is the thing, we want to go to Supreme Court 5 times. And either because we have money or because professionals like you and me advise them, yes, you have a case, please give me money, I will go to Supreme Court 5 times. So, whole purpose of this law, the fundamental purpose, the ultimate purpose, all these are recovery, resolution, these are actually the superficial benefits. The fundamental thing is that people should have a freedom from failure. Recently, Prime Minister spoke in on Kilokar Institute about this, that until you people celebrate freedom from failure, until you celebrate failure, country can't move. And that failure means people should be willing. I have failed in the business. Let me move on in my life. Let somebody else come in. If he can manage, let him manage. Otherwise, let the assets and people should be freed from the chakravyuha. Until you accept that, as long as you think that I have given my sweat, I have done this company, I can't let it go from my hands, then actually we are not working in the true spirit of the code. So we have to change our nature actually, because why the courts take time, why so much of litigation, why time is wasted. Madam says this is that is high. I consider even 180 days is high. I had written earlier sometime also. 180 days is also too high. What do? You are saying that you are working out a deal. Why do you need so much time? If there are people to resolve it, they will come forward on the day one. And information is available today much before. So I don't think that we have to just accept. There will always be people who had a vested interest in the earlier order. They do not want change. But if you are willing to change, move with the change, timelines will fall in line, everything will move, and we should celebrate. Thank you.
Dr. Sahoo, we had one more query about group insolvency. Could you please enlighten us about that? I believe the IBBI is working towards some sort of a plan or guidelines regarding group insolvency.
IBBI had set up a committee. A report is available that is giving a framework, but in the world, there is no good group insolvency framework. Today in the world, no country has a true group insolvency framework because there are limitations. Limitation is that we say that a company is an island, another company in the group is also another island. If you put these two companies together, the rights of stakeholders of company A may be different from the rights of stakeholders of company B, or at least even if there are overlapping, there could be one person who is different. So basic principle of a company's own identity and treating the whole group, this comes in the question. That is why it has not been successful. There is not an acceptable framework in operation anywhere. But people think in two stages. Let's think of procedural coordination and substantive coordination. What is not there is substantive coordination is not there anywhere in the world. But there is a coordination. That means there can be one IP, one NCLT, there can be two COCs can talk to each other. This kind of facilitation should be there, is there at many places, and that is what this committee has recommended as a first step. And this is what, as Honorable Justice mentioned, that the NCLT and LAT are facilitating. He gave an example he gave, and there are also few others where they are facilitating, and in fact that is our experimental.
Thank you, Dr. Sahoo.